Imagine this. Your wife is 8 months pregnant. She's having contractions. You rush her to the emergency room. You're sitting in the waiting room terrified, holding her hand, trying to stay calm. And then two men in plain clothes walk in. They're not doctors. They're not nurses. They're ICE agents, scanning the room. If you're like most people I hear from, you believe one of two things. Either you think, hospitals are safe zones. ICE can't do anything here. Or you think, hospitals are a trap now. I should never go back. Both of those beliefs can hurt you because they push people into the two worst decisions: false confidence or dangerous avoidance of medical care. I'm Michael, and this is US Policy Brief. We don't do rumors, we don't do panic clips, and we don't do friend of a friend advice. We do real policy, real rights, and real-world steps you can actually use. Today, I'm going to do 3 things. First, I'll explain what changed with federal protected areas or sensitive locations guidance and why hospitals are not a guaranteed enforcement-free zone. Second, I'll walk you through 5 traps that are getting people detained or put into proceedings after hospital encounters. Trap number 4 is the one that catches even green card holders off guard. Third, I'll give you a legal shield, the exact calm words to use if ICE approaches you or someone you love in a healthcare setting without escalating anything. What changed and why the safe zone assumption is risky now. For years, DHS had internal guidance that encouraged agents to avoid enforcement at certain sensitive locations, including places like hospitals, schools, and houses of worship, except in limited circumstances. That created a public perception that hospitals were basically off-limits. But those policies are agency guidance, not a constitutional law that permanently blocks enforcement. They can be changed, narrowed, or rescinded by the executive branch, and they also vary in how they're implemented on the ground. The most important point for 2026 is this: you should not assume there is a blanket federal rule that automatically prevents ICE from showing up at a hospital. Depending on the current DHS, ICE guidance, and local practice, enforcement actions may still occur, especially in public areas, or when ICE is looking for a specific person. That does not mean you have no rights. The Constitution did not disappear at the hospital door, but it does mean you need to know what the actual traps are and how to respond correctly. Trap number 1. Believing the old sensitive location rule still protects you automatically. This is the first trap because it creates a false sense of security. People walk into a hospital thinking there is an invisible legal force field. They can't touch me here. Then they talk casually, show extra documents, or assume they don't need a plan. Hospitals may still be places where agents often avoid enforcement in many situations, but often avoid is not the same as cannot. The safer mindset is, go get medical care, but go informed. Trap number 2, talking when you should stay silent. This one breaks my heart because it's the easiest to avoid. If ICE approaches you in a public area, like a hospital lobby, waiting room, cafeteria, sidewalk, or parking lot, they may ask questions, they may sound polite, they may act like it's just a conversation, but anything you say can be used to build a case, confirming identity, country of birth, where you live, how long you've been here, whether you have status, whether you've had prior contact with immigration. You generally have the right to remain silent under the Fifth Amendment, regardless of immigration status. Silence is not suspicious. Silence is a constitutional right. A safe, simple sentence you can use is, I am exercising my right to remain silent. I want to speak to a lawyer. Say it calmly, then stop talking. Trap 3. Running or physically resisting inside a hospital. Some people see agents and panic. They run down hallways, try to hide, or physically pull away. Don't do that. Running or resisting can turn a civil immigration encounter into a criminal situation. Obstruction, resisting, interference, depending on the facts and the state. And once criminal charges enter the picture, immigration consequences can become much more severe and much harder to fight. Stay calm. Don't lie. Don't run. Don't resist. Use the script. Ask for a lawyer. Trap number 4. Not knowing the difference between a judicial warrant and an ICE administrative warrant. This is the one that catches even educated people. And yes, it can catch green card holders and visa holders too, because it's not about status. It's about what ICE can legally use to enter non-public space. There are two very different pieces of paper ICE may present. A judicial warrant is signed by a judge, for example, a federal judge or magistrate judge. It is the type of warrant that can authorize entry into private areas under the Fourth Amendment, depending on what it says. An administrative warrant, often ICE forms like I-200 or I-205, is typically issued within DHS and signed by an immigration officer, not by a judge. Many civil rights organizations and legal experts argue that an ICE administrative warrant, by itself, does not authorize entry into non-public private areas without consent. Hospitals usually have public areas and non-public areas. Patient rooms, treatment areas, staff-only zones, and many back areas are typically treated as non-public. What this means in plain terms: if ICE is trying to go into a non-public area, hospital staff can ask, "Do you have a judicial warrant signed by a judge?" If the answer is no, staff may refuse entry into non-public areas without consent and request the hospital's legal team. If you work in a hospital, this distinction matters. If you're a patient or family member, it matters because it affects where ICE can go and what staff can legally do. Trap number 5. Signing papers you don't understand, especially under stress, illness, or fear. Hospitals are where people are most vulnerable. Pain, fear, medication, trauma, exhaustion, postpartum complications. That's the worst time to sign anything. If you are presented with paperwork, especially anything that sounds like voluntary departure, stipulated removal, withdrawal, or anything about giving up rights, do not sign on the spot. A safe response is, "I don't understand this. I won't sign anything without speaking to my lawyer." Signing the wrong document can waive hearings and trigger long-term bars. Even if you think you're just signing to go home, you may be signing away your chance to fight your case. The legal shield. What still protects you in a hospital in 2026? Now, I want to be very clear. Rights are not magic words. You still need to stay calm and avoid escalation, but there are core protections that remain. Shield 1. The Fourth Amendment, search and entry rules. ICE can generally be in public spaces, but entry into non-public private areas usually requires proper legal authority or consent. Hospitals can control access to non-public areas and can demand a judicial warrant for entry, depending on the circumstances. Shield 2. The Fifth Amendment, right to remain silent. You can refuse to answer questions about status, birthplace, how you entered, or anything else that could be used against you. Shield 3. HIPAA, medical privacy protections. HIPAA restricts how medical providers disclose protected health information. Hospitals generally are not required to collect immigration status for treatment, and they are not free to share private medical information with ICE just because ICE asks. There are exceptions and legal processes, but ICE asked is not automatically enough. Some states also have additional protections limiting cooperation or disclosure beyond federal minimums. The details vary heavily by state. Shield 4. EMTALA, emergency care requirement. If it's an emergency, hospitals must provide a medical screening and stabilizing treatment, regardless of immigration status or ability to pay. They cannot lawfully demand immigration papers as a condition to stabilize an emergency medical condition. Your action plan: save this. Step 1. Memorize one sentence. I am exercising my right to remain silent. I want to speak to a lawyer. Teach it to every adult in your household. Practice it. Step 2. Carry a Know Your Rights card. Organizations like the ACLU, NILC, and ILRC have printable cards. If approached, you can hand over the card and say nothing else. Step 3. For hospital staff. Set a protocol now. Designate who is authorized to speak to ICE. Train staff to say, "I'm not authorized to consent to entry. Please wait while we contact our supervisor legal team. Do you have a judicial warrant signed by a judge?" Step 4. Have an emergency legal plan. Know who to call. Have a family plan for children. Keep key documents and phone numbers accessible. Preparation is not paranoia, it's risk management. One last message: please don't avoid medical care. Fear is understandable. But skipping prenatal care, delaying emergency treatment, or avoiding vaccines can cause irreversible harm. EMTALA exists for a reason. And your health and your child's health matter. Go to the hospital when you need to. Just go informed, calm, and prepared. Everything in this video is general information as of March 2026. Policies and court rulings can shift quickly, and local practices vary. For advice on your situation, speak with a licensed immigration attorney or a qualified legal nonprofit in your area. If you want ongoing updates like this, subscribe to US Policy Brief and turn on notifications. And if you know someone who still believes hospitals are automatically safe zones, share this video, because one misunderstanding can lead to a mistake that is very hard to undo. I'm Michael. Stay informed, stay prepared, and I'll see you in the next update.